choice option on every question, that doesn't get you there. Because when you circle the wrong ones, you get penalized for that. So you only get full credit if you get all the right answers and none of the wrong answers. Now, not all the multiple choice questions have more than one right answer, but some of them do. And sometimes the call of the question will tell you that. Name the two most important factors in X. Don't just put one, put two if it asks for two. Now, not all the questions do that. Some of the questions, there's more than one right answer, and you really can't tell from the call of the question that there is. There will also be, I don't know exactly how to describe it, but matching questions where we will give you a list of legal standards. Probable cause, reasonable suspicion, proof beyond a reasonable doubt, no justification needed. And then we will give you a series of examples. You know, the police go up to somebody in a bus terminal and say, "Hi, how you doing today? Mind if I talk with you a little bit?" And you have to pick what the proper standard is for that police action. In this case, it would be no justification necessary. The police pat down an individual's exterior clothing for weapons. What's the standard? Articulable suspicion that he's armed and dangerous. You would pick that one. The defendant is convicted of a crime. What's the standard? Proof beyond a reasonable doubt, and so on. Okay, there'll be a number of those. There'll be standard true-false questions, and then there'll be short answer questions, where you don't have to write an essay, but you have to write a couple of sentences or list a couple of things that would apply to that particular situation. When you take the exam, read it carefully, because you want to see if you're using the terminology precisely. So if somebody were to ask you, true or false, probable cause is required for a pat-down, the answer is false. Okay? Probable cause would give you the right to pat down, and it's not required. All right, so that describes the structure of the exam. Let's talk a little bit about the questions. I think I told you in the very first class not to miss Mr. Conway's class, the second class on criminal procedure, because the midterm, you have a lot of questions about criminal procedure on it, because you have to know the rules of the playing field to understand plays that are being made. A sport would not make sense to you if you didn't know what the rules were, and motions to suppress won't make sense to you unless you know what the rules are. So there will be a lot of questions on criminal procedure. There'll be questions about grand juries. What a grand jury does is indicts. If it decides to indict, it's called returning a true bill. If it decides not to indict, it's called not returning a true bill. The rules of evidence don't apply in grand jury proceedings. The investigator can go in there and say, you know, this is what I was told, this is the hearsay I learned, all these types of things. The defendant has no right to be present. It's a what we call an ex parte proceeding. The cop goes in, detective goes in, he talks to the grand jurors, they make a decision, that's it. This is not an investigative grand jury like you see frequently used in federal level. It's used at the state level too. This is an indicting grand jury that we're talking about. Know stuff about the rights of discovery in Virginia. Mr. Conway went over that. What can the Commonwealth learn in discovery? What is discovery? Discovery is a process that litigants use before trial to learn things about the other side's case, to discover things about the other side's case. In Virginia, the defense can learn statements of the defendant to the police, what he said. The defendant can learn and get copies of any written scientific reports or physical examinations done on him. So if we do a ballistics test, if we do a DNA exam, if we do blood alcohol, and there's a written report generated, he's entitled to get a copy of that. He's entitled to look at the physical evidence that we're going to use, the pictures of the crime scene, the murder weapon. He's not entitled to names of witnesses. He's not entitled to statements of witnesses. Virginia is very much in criminal trial by ambush. Not just prosecution, ambush, and defense, but the other way around. Whenever I cross-examine a witness from defense, I don't have the opportunity to talk to him at that time. I'm doing blind cross-examination right in the courtroom. The Commonwealth has a right to discovery too, but it's more limited. When the defendant requests discovery, then he must tell us if he's going to rely on an alibi. And he must tell us if he's going to rely on insanity. He doesn't have to tell us about those things if he doesn't request discovery. We don't get to learn anything about his witnesses, who they are, or what they're going to say. There are different types of appeals. What do you have to do to note your appeal from a conviction for a misdemeanor in general district court to circuit court? You've got to note that appeal in writing within 10 days. And what do you get when you do that? A trial de novo, a brand new trial. Your conviction is wiped out in district court, and you start all over again in circuit court with a brand new trial. In circuit court, when there's a conviction, the defendant has the right to petition for appeal. He may not get one, but he can ask for an appeal on anything that the court does that he doesn't like. An evidentiary ruling, keeping a piece of evidence out. An evidentiary ruling, letting a piece of evidence in. A ruling on jury instructions. Anything that he feels that the judge did wrong, or the jury did wrong, he can petition for appeal. By contrast, the Commonwealth has a very limited right to appeal. It can appeal suppression of evidence based on the 4th, 5th, or 6th Amendment, or the declaration of a statute to be unconstitutional by the judge. The only things the Commonwealth can appeal. If the judge makes an evidentiary ruling that is completely wrong, there's nothing the Commonwealth can do about it. And don't think that the judges don't know that. And don't think that they rule the way they want to rule because we can't appeal it. Well, I understand your objection, Mr. Willett, but I'm going to let it in. Nothing I can do about it. I got to just suck it up and deal with it. Know the basic order of how things proceed. Someone is arrested on a felony. Typically speaking, if it's an arrest warrant, then what does he get? He gets a preliminary hearing. Then he gets his case presented to the grand jury for indictment. Then it gets set for trial. But if the police don't arrest him on a warrant, and they go directly to the grand jury for an indictment, and then after the indictment is issued, they arrest him, he doesn't get a preliminary hearing. It's arrest warrant, preliminary hearing, grand jury, trial. Or skip the arrest warrant, skip the preliminary hearing, go directly to the grand jury, go directly to trial. Know that in a jury trial, in a criminal case, the jury has to decide by unanimous vote. Not just conviction, but if conviction, also punishment. Whereas a grand jury does not have to indict by unanimous vote, they do it by majority vote. Know that anything in this criminal process, we talk about due process. Well, what is that? Well, a process is just that. It's a step. And if it's due, it means it's owed to the person. So due process are the steps that I'm entitled to. If I'm going to be tried for a felony, I have a due process right to a preliminary hearing, to an indictment, to an attorney. I have a due process right to confront the witnesses against me, cross-examine them, a right to a jury trial. All of these processes which are due to me, which are owed to me, all these steps that are owed to me, I can waive any of them or all of them. Okay? They're my processes. If I don't want to avail myself of them, I can waive them. When a guy pleads guilty, he waives everything except his right to counsel. He waives the right to confront his accusers. He waives the right to jury trial. He waives all those kinds. So anything can be waived. Know that grand jury testimony in Virginia is not open to the public, whereas trial testimony in Virginia is. It's a public trial on a crime, but a private proceeding for indictment. Unlike a grand jury proceeding, the rules of evidence do apply to a preliminary hearing just like it was a trial. So if I ask the officer, what did Joe Smith tell you, and the defendant says objection, hearsay, I'm done. With respect to the powers of the police to arrest, typically, although there are some exceptions, to arrest them for a misdemeanor without a warrant, the misdemeanor has to be committed in their presence. With felonies, however, without getting a warrant, the police can arrest for felony whether or not it was committed in their presence, so long as they have probable cause to believe that it was. Note that if there is an illegal arrest, it doesn't deprive the court of jurisdiction to try a case. It may result in the suppression of evidence that was seized as a result of that arrest, but if the prosecution can proceed without that evidence, the court has jurisdiction. So a guy comes in, I was illegally arrested, I want this charge dismissed. You lose. I was illegally arrested, they took my wallet as part of the arrest, and they're going to use that evidence of the wallet against me. You win. You can be prosecuted, but they can't use the fruit of that poisonous tree. All right. There'll be questions on the exclusionary. And on, let's look at the exclusionary rule. Know what the fruit of the poisonous tree doctrine is. It means that if we obtain evidence as a result of violating somebody's constitutional right, we can't use that evidence. So somebody's arrested without probable cause, the search incident to arrest, they find cocaine in his pocket, they charge him with possession of cocaine, Commonwealth loses that case. When does the good faith exception to the exclusionary rule apply for purposes of this class? When there's a search warrant and actual good faith. say to you, I believe that's changing, but that's not something that we want to talk about in this class. What's the purpose of the exclusionary rule? Quote, to deter police misconduct, close quotes. Who has the burden in a motion to suppress? The government. The government, the government, the government. Even if there's a search warrant, although the search warrant makes the search presumed reasonable, the burden is still initially on the government to prove that they did it by search warrant. What is the standard of proof? Preponderance of the evidence. To convict somebody, you got to prove it beyond a reasonable doubt. To win a motion to suppress, we have to do so by a preponderance of the evidence. Think of a lady, justice lady, blindfold, sword in one hand, scales in the other hand. One scale just tipping slightly in favor of the other, not 51%, more than 50%. So 50.01%. Okay, you know what the requirement of standing is. Reasonable expectation of privacy in the place or thing to be searched. Search warrants. What are the requirements? Particularized description of the place to be searched. Particularized description of the items to be seized. Affidavit of the oath establishing probable cause. Detailed inventory of what was seized. The knock and announce rule, execution of search warrants, not constitutionally required. And obviously, there'll be a number of questions about the exceptions to the search warrant requirement. Know the requirements of search incident to arrest. A valid basis for arrest independent of the search. The search and the arrest have to be substantially contemporaneous. When we say search incident to arrest, we tend to think, well, the arrest comes first and then the search comes. And that's how it happens 99 times out of 100. It doesn't have to happen that way. As long as there's already probable cause to arrest, they can search and then arrest if they do it all at the same time. What are the two purposes of a search incident to arrest? To keep the defendant from getting a weapon and to keep the defendant from destroying evidence. Basic consent law, who can consent, what's required for consent. Acquiescence isn't enough. Consent can be limited, consent can be revoked. Plain view. The police were lawfully present when they made their plain view observation. And when they made their plain view observation, they had probable cause to believe that they could seize what they were looking at. Stuff that we went over today about words used to obtain consent, words used to give consent, stuff we went over today about how to abandon property, physically relinquish it, throw it away, or deny ownership or connection with it. The difference between a full-blown search pursuant to exigency and a limited exigency search to secure the premises. Securing the premises, the only thing that police can look for is people. Full-blown exigency, they can look for whatever they want. All searches without warrants are presumed unreasonable. Standards for a pat-down. I think that pretty much covers it. Any questions?